Gracious and Heavenly Father, we thank you for life. We thank you for the blessings that you continue to give us. We thank you for your presence as we go through the daily proceedings. This meeting to which we are starting again in pursuance of finalization. We ask for your guidance, your continued presence, molding our thoughts as we go through. These we ask in your merciful name. Amen.
Amen. Thank you very much. The minutes, first of all, we have apologies for absence. Any formal apologies? None that I hear. So those who are not present, well, you'll have to record as absent, since they did not tender any, well, even then you would have to record as absent. I'm very pleased that we're back to bring this JSC, I hope.
Good morning, Mr. Chairman and the team. The TV microphone that you are coming through on is muted. I'm not hearing. I don't know if that's happening to anybody else who is online.
I'll ask the technology folks to try and fix that. Is there anybody around that can answer that for us? All right, Senator Allen, they're working on it. So let's just wait a minute or two. Will you just inform me, sir, when you think we're online, so I can, or when they can hear us? Good to see you, Senator Allen. Well, she can't hear me anyway, so. But why do we have this every time? Every time we start, we should work. That's what it's here for. So, Madam Clerk, can you say to the clerk that they should test the equipment before we start, so that when we start, it works? Please make a note and tell the clerk. Any luck, Mr. Technology? No. Well, we have a an echo. You want me to try it again? Senator Allen, can you hear me?
Yes, I can now hear you.
Right.
Thank you.
We're in business. Thank you very much, Mr. Technology. And we've had prayers. No apologies that we've had for absence. Very pleased that we're back at this Joint Select Committee, looking now to head to home, to the curve. So we have much of the work done. I know there are responses to some issues that were raised. So I'm going to ask that Mrs. Viola Evans-Roberts will lead us today. And, right? And you? Oh, that small matter there. My office is telling me that we have to look at the minutes, which is right. The minutes are presented. I take them as read. Are there any amendments that anyone would want to bring? All right, no amendments. I'm going to ask then if Senator Gale, you'd move for the acceptance of the minutes. Okay, Senator Gale has moved. Senator Allen, will you kindly second for us?
Seconded.
Thank you very much. Minutes are accepted. Moving now to Mrs. Roberts.
Thank you, Minister. Good morning, everyone. The last time we were here, there were 3 issues raised, and that's what we are going to be addressing today. Issue number 1.
Make sure you speak into the mic there.
Issue number 1, an advisory board. When it was presented the last time, the committee inquired whether it was best practice, and we have done our research, and after careful review and consideration, we have decided to withdraw this recommendation.
Can you say what it was just quickly for the record? What the recommendation was and why?
To set up an advisory board for the Office of the Supervisor of Insolvency.
And after consideration,
We have withdrawn it. We have withdrawn that recommendation.
All right, next one.
Virtual meetings. Jambara had recommended that the Act be amended to establish other methods of creditors' participation in meeting, virtual and otherwise. There was a recommendation for a creditor, that a creditor may participate in a meeting by means of a telephonic, an electronic, or other electronic means. The members were of the view that the provision was too broad and added that there could be legal implications. Communication issues. It was recommended that the specific means of communication be listed. That's what the recommendation was. But upon review of best practice in other jurisdictions, including the UK and Canada, it was noted that these legislation, they set out the criteria that the medium used to host the meeting should meet, but they do not prescribe the specific means. So we have agreed that it does not need to prescribe the specific means. So the key provisions that we are recommending now is that the meeting of creditors may be held by hybrid means where the trustee is satisfied that each attendee is able to attend and fully participate in the meeting if held. So we are concerned that there are no restrictions in the participants being able to participate in the attendees being able to participate in the meeting. Hybrid meetings would have the same effect as in-person meetings. Again, no restrictions. Provisions for the proceedings for hybrid meetings, including the procedure for the delivery of notices and other documents and what is to be included in the notice. Verification of attendees would be done, and the effect on quorum of inability to participate in hybrid meetings where persons who have joined by virtual means are not able to participate. So the legislation will make sure that those are addressed and facilitate voting by the following methods: a voting software installed.
Before you move.
Yes, Minister.
How will quorum be decided? Should quorum be from the attendees in person so that there is at least the chance that it will in fact be a hybrid meeting? So quorum should be comprised. I'm asking because otherwise there is no way to have a hybrid. What you call a hybrid could easily then become a virtual meeting unless you have a requirement that certain number of people must be in the room, and that would be quorum.
You are correct, Minister, but the details will be worked out in the provision to make sure that the matter of quorum is settled, because there would be, at this time, the practices, let me tell you what the practice is. The trustees, they meet in the Office of the Supervisor of Insolvency, so that's the in-person section of it, and the others are online. So we will make sure that in relation to quorum, at least one person is present, because the quorum under the Act is one person who is able to vote. At least one person is in office. But the details will be worked out later.
Tell me this. How many people are in the meeting?
In any,
How many you could have?
there can be multiple, very many persons. There could be 2 or 3, but the Act provides. Yes, very.
Okay, so you have a really small quorum.
The Act provides, Minister, that one person in a meeting of creditors who is able to vote constitutes a quorum.
And why is it so small? Just for interest.
The legislation, I think there were, yes, for meeting of creditors to be effective, you don't want to have any delays, yes.
Okay, all right.
Yes,
So then, I heard what you said, but we're now looking at drafting the legislation.
Yeah.
And if we have decided that the meeting should, A, not be virtual, then for hybrid to be hybrid, for the quorate number must be present. So since we're writing that, it must be in there so that it doesn't become virtual when we really mean hybrid. Clear?
Correct, Minister, and we understand, yes.
All right.
And that will be worked out.
And that will be done, and
Yes.
and written, codified.
Yes.
Thank you.
Minister.
All right, move along.
Thank you. The other issue was with Section 202 of the Act. There were different recommendations, and I'll read through the various recommendations. There was an amendment to 201 to provide that the expenses and fees of a trustee acting or who acted under Part 3, that's a proposal regime, should be a Category 1 payment. The issue is the present legislation provides for trustee who is acting for a bankrupt or who is acting as receivers, their fees are Category 1, but it did not include trustees acting under the proposal regime.
Right.
There's a recommendation for that to be amended, and we have agreed with that recommendation.
Okay.
For number 2, this was agreed after consultation. For sections 202, it recommended that subsections 2 and 3 be deleted in their entirety and replaced with the following. The proceeds realized from any property not comprising security held by a secured creditor shall be applied in priority of payment in descending order. What happened is when the Insolvency Act was passed in 2014, Section 311 of the Companies Act was removed and replaced with the provision stating that Section 202 of the IA would govern the ranking of claims for payment of proceeds from the debtor's property. This language aimed to align the order of priority under the Insolvency Act closely with the previous order established by Section 311 of the Companies Act, along with Section 302 regarding the cost of voluntary winding up of the Companies Act. However, Section 202 of the Insolvency Act extended this principle further by prioritizing all preferential debts over the claims of fixed charges. And of course, that would not be the case. That was not acceptable. So the new proposed Section 202 is intended to address this by providing that it is dealing with the proceeds not realized from the proceeds realized from any property not comprised in security held by a secured creditor, which would then be applied in priority of payment as Category 1, cost of administration, then Category 2, and then Category 4. And I'm seeing Mrs. Sutherland Reed here, yes.
So just for clarity, all that is doing is ensuring that the secure creditors are given the priority before the other preferential creditors, and that was the intention. That was not reflected, as it was an oversight in the past, which is being corrected.
Yes. So this would be in agreement with the Act that provides that all claims are subject to the rights of secured creditors. Amended now, that would be preserved. So we have accepted that recommendation. Yes, the next recommendation, subsections 4 and 6 should be amended to delete the reference to subsection 3. We disagreed with that one because having made amendments to subsection 3 now, this amendment is no longer required. And the final one, Jambar requested a revised section in relation to proposal as well, which we agreed, because it is our view that when a proposal has been approved by the court, the scheme of distribution in section 202 does not apply at all, because based on proposal mechanism, it is what is agreed between the creditors and the debtors that apply, not so much section 202. Of course, when trustees are dealing with the how it should be, payments should be made to the creditors, they do give consideration to the preferential creditors and so on as set out by section 202, but they're not bound by it because this is a proposal and it is freedom of contract between the debtor and the creditors. So amended now, that would also preserve that in the Act.
In this aspect, Chair, it is where they would have agreed, and that would take precedence.
Certainly. Yes.
Okay.
Thank you. There is a final one, PricewaterhouseCoopers recommendation that rent becomes a preferred treatment, be given preferential treatment under the Act, and we agree with that. It fills a gap where landlords are unwilling to allow bankrupts to remain in the property unless they receive some rent. As a matter of fact, that had been the practice under the old regime where the government, Office of the Government Trustee found that worked, that everybody live harmoniously because at least the landlord is given some of his rent.
Right.
Yes.
Sounds reasonable.
We are accepting that recommendation as well.
That's it?
That's it.
And then where do we go now? We have a recommittal because we have an apology for absence from Minister Don Webby. Right, Madam Clerk, we have a recommittal for the recording of the absence of Senator Don Webby. All right, where do we go now, Madam Clerk?
Mr. Chairman?
Yes,
May
member.
I just ask a question?
Yes,
And
member.
I'm sorry to take the committee back to the recommendation in relation to the mechanism for meeting.
Yes.
I just wonder, and forgive me if I am not recalling, we're putting in a provision in relation to hybrid meetings.
Yes.
Is there a reason why we wouldn't consider a wholly virtual meeting?
Go ahead, please.
We have observed, based on the practice, that when there is a virtual meeting, full virtual meeting, it is common for the participants to be very distracted. Sometimes there is no interface between the parties. The physical meeting allows for that discussion. So having a full virtual meeting, the result may not be as intended because of lack of participation and real commitment, the distraction. Persons are doing other activities, etc. So I don't know what the view is.
There is another consideration. When you're discussing even important policies, virtual meeting might very well hold. When you're discussing something that really can be life and death to somebody, money, their business, their livelihood, you want people to be focused. And I believe that if you're going to do that with persons' lives, it's necessary to be able to make sure people are focused and the decisions are made are the ones that really people have discussed and want to go forward. So it's because of the gravity. I'm supporting it, Senator Golden Campbell, because of the gravity that is involved. I know from my real life professional experience that when money is involved at this critical stage, people need to look at each other in the eye and come to the best decisions they can. So that's the reason I would support it.
Except, Mr. Chairman, in making a provision for hybrid meetings, in the manner in which the recommended provisions have been set out here.
Yes.
You could have a meeting where the only person who is in person is the trustee, and everybody else is virtual. That would qualify as hybrid. So you would have, in effect, the same sort of situation as if the trustee was also virtual.
The issue is my belief, Senator Golden Campbell, is that once the trustee is in resident and my issue is my issue, I'm going. And
I would agree with you, Chairman. I would go as well. But if we're making a provision for a hybrid meeting, and the reasons being given is the question of the distraction of parties. I mean, parties would, in my view, have an interest in appearing in person. But if we're making a provision for hybrid meetings, I'm just not understanding why we're even putting that restriction if we're seeking to allow for virtual attendance. Because you could, if the trustee is the only one sitting in person, then you essentially have everybody else virtual.
You remember how we arrived at trustee? I asked what was the quorum. So unless you change the quorum, because that's why I asked the issue of what was quorum. And I said that those, to make it quorate, the quorum would have to be present in person. So
and the quorum is how much again, Chairman?
The quorum is 1, which is why then we might have to look at the quorum being different, because I really, yes, I see.
We are having discussions here, Minister, and we are agreeing that.
Ms. Eaton, do you want to come in and say something?
The side discussion that was taking place here, that from a drafting perspective, certainly, if it is that you need or require for the purpose of the policy different quorum requirements because of the methodology of the meeting, that can be provided for.
Good.
The issue is, what is the policy?
And that's why, thank you so much, and that's why I was very clear about what the quorum. So it sounds to me like you have to change the quorum. And you make sure the person whose property they're looking to take and those who want to take it are present in face of the trustee. So you change the quorum so they all sit down together and talk about it face to face, because, you know, if this is not done, sometimes it gets very irritable and bad things happen.
Which then, Chairman, defeats the purpose of a hybrid meeting.
Thank you very much.
What exactly, and the policy is not clear to me. Either we're looking to have, to facilitate virtual meetings in which parties can participate from overseas, from wherever they are, or we're not.
Well,
but having a hybrid meeting where you have the trustee alone, if the quorum is 1, and I don't really see how the trustee alone can make up a quorum.
That's how the law is written. But we're past that now, Senator Golden Campbell, because I asked that question, and that's the reason I agreed to it, but it clearly doesn't make sense. The parties involved must be in the room. And when it came to me, because of what it is, I did not like hybrid meetings, as you will recall. So
then, Chairman, we're saying then that parties... So then, Chairman, we are saying then that parties cannot attend virtually. That's what it sounds like.
No, not necessarily. So let's interrogate it a bit. Senator Cavengale, you want to come in?
Thank you, Chair. I'm of the view that what was being recommended is to ensure that in the first instance, people who are not able to be physically participate. And that's why the concept of the hybrid comes in. Now, there has to be certain scriptures in terms of what constitutes quorum and who ought to be present.
Right.
So maybe we need to define that for quorum purposes and for voting purposes.
Well,
Yeah?
because we do not want to have a hybrid meeting where the parties that are germane to the decision are out of the physical meeting, the quorum then will have to be reconstituted. I wouldn't say that we wouldn't have hybrid, because you might have a lawyer overseas that might be germane to the meeting, but,
Yes.
but it doesn't have to be in the meeting. And we would want to accommodate them in this age of technology.
Right.
But the people to whom the decision is germane, quorum must be written that they're present, and other assistants can be hybrid. So I'm going to, Senator Golding, I want to bring you back in and see how that sits with you. Senator Golden Campbell, your picture is pretty, but I can't hear you.
Sorry, Chair. No, Chair, I agree. I think you have to address the quorum if you want to effect what you just said, and I would agree with you. It just means then that in relation to the policy position, that we are not providing for parties whose interest it is being determined. We're not providing for them to attend virtually.
Absolutely right. That hits it on the nail, and the document will be recorded in that fashion. And thank you so much, Senator Golden Campbell, because I was uncomfortable with this one nonsense. Sorry, I mean this one trustee. I misspoke.
Very well, Chairman.
Thank you very much.
So it's agreed then that we will revisit the quorum for the hybrid meetings. Thank you.
All right, I've been given some directions here. We're looking now, we're at the stage that a draft report, as amended, will be circulated. That's one. Number two, the committee needs to meet after a reasonable time that a draft report has been out to come back and consider the draft report. After the draft report is finalized by the committee, members will sign it and it will be tabled in Parliament. Now, I am most excited about that last part of the guidance I've been given by Madam Clerk. So we need to get the signing part and transmit to Parliament. Yeah, so you have to. So we're going to get the report out, give it reasonable time, Mrs. Sutherland Reed and Mrs. Roberts, and then we call the meeting together again to consider the draft report, finalize it, and have it off to Parliament. But this now, it must be a time to say many, many thanks to all of you who have worked so hard. The support team, we start with you there. I'm particularly appreciative because you guided me. I got the briefs. Mrs. Sutherland Reed sat with me sometimes. Mrs. Roberts sat with me and went over it. So when I came here, I knew why I believe what I believe. I know why I'm here. But my colleagues, I'm sure my senatorial and parliamentary colleagues would feel the same way, because also the clerk, the staff at the House, been very on time, punctual, getting this stuff out for us, made the committee work, I think, a lot more efficiently. And especially now to my parliamentary colleagues for sitting the time, going over it. We went through a lot of sections and subsections and all kinds of stuff, learned a lot in the process, and I'm glad we're at this point, and thank you for taking us here, and we look forward to getting to the end in a relatively short period of time, and Senator Gale wants to speak.
I must say, and I commend the team, one of the things I learned from going through this committee was the level of preparation in coming to the sessions. Making recommendations as part of the proposal to form the new legislation, but coming with the rationale. And that's important. So it gives us a clear understanding of the direction and the intention of the legislation. And I feel that this was one committee that I've been part of that it was efficiently done. And by your, I don't want to misspeak, Chairman, but you really anchored this in a very
you can speak
almost
up.
draconian
No, really, speak
way.
up, speak up. Speak up, Senator. No,
But it
thank
was
you.
done efficiently, sir, and I commend you on that.
Thank you very much, and thank you all so much. Yes, Ms. Eaton.
Thank you, Chair. I just wanted for us to remind ourselves that, bearing in mind that this is the review of an act of Parliament,
Yes.
and that the Office of the Parliamentary Counsel has not yet been released to draft,
That's
that
you.
there may be
That's
some,
you.
yeah,
That's
there may be some refinement or
understand
adjustment
that,
of the
yes.
text that is reflected.
Because you're going to look at which acts are, or bills or subsections of other bills that are affected, and you will
Yes.
make sure it's nice and proper for us. But I think much of the work has been done, and knowing how you do your work, it's going to be quite well when you're finished with it. Will be much better. It can't be worse, so we look forward to your comments. And thank you very
Well,
much. Ms. Eaton.
Yes, Minister. Chair.
You notice? She just want to make sure, hey, you're not going anywhere unless I say so. But thank you all from the OPC for the help that you've given to us. We really do appreciate it. Any other matters that we need to discuss before we close? None. Then I'm going to accept Senator Gale's motion to terminate this meeting. And Senator Golden Campbell, since your pictures
I second it.
Thank you very
Chair.
much. Thanks a lot. And thank you all for coming this morning. I look forward to really heading to the termination of this JCS. Madam Clerk, thank you very much.